In recent months, public attention has focused on the relationship of the United States to its territories, those entities under federal law that are not one of the 50 states, but whose residents live within the legal framework which governs us all, the U.S. Constitution. Places like Guam, the Commonwealth of the Northern Mariana Islands, American Samoa, the U.S. Virgin Islands, and Puerto Rico are all territories. For the next few minutes, I will be talking about the manner in which the 18th century framers of our Constitution both empowered and limited government to deal with territories in our then expanding frontier. The modern trend among territorial populations to resolve national identity and achieve permanent status makes the correct interpretation of U.S. territorial law an urgent priority for the 21st century. Article 4, Section 3 of the U.S. Constitution gives to Congress the power to govern territories. Since the first 13 states ratified the Constitution, the U.S. has acquired sovereignty over at least 40 populated territories. 34 of 37 states later admitted to the Union had been U.S. territories governed by Congress. Today, the United States governs 5 populated territories, each with a congressionally organized civil government. The oldest and most populous of these is Puerto Rico. Each organized territory has its unique geographic, political, social, and economic characteristics. All territories, however, possess underlying principles in common, and any political status resolution is based on these fundamental features of territorial status. For a U.S. territory to obtain permanent political status, it may do so within or outside of U.S. sovereignty. Depending on the permanent status which it achieves, it will end up on one side or the other of the constitutional wall that separates those within and those outside of U.S. sovereignty. Within U.S. sovereignty, only states of the Union have a political status defined by the U.S. Constitution, a status that cannot be altered without a constitutional amendment. Statehood ends the territorial power of Congress and establishes a constitutionally guaranteed and permanent union. Statehood also grants U.S. nationality and citizenship, full representation in the federal political process, and equal individual rights. In contrast, the political status of other territories within U.S. sovereignty is defined by federal law or treaty, flowing from the territorial clause powers of Congress. There are 3 categories of U.S. territory within U.S. sovereignty: incorporated, unincorporated, and possessions. Incorporated territories are those that Congress has put on the path to statehood with its attendant equal civil rights and responsibilities. The 34 territories that became states did so in accordance with terms of an admission act approved by Congress. Unincorporated territories are those that are within U.S. sovereignty, but for which Congress has not yet approved a statehood or independence enabling law. Unincorporated territories have local government organized under federal law with a political status and citizenship defined by Congress, including the delegated right to exercise sovereignty in local matters. An unincorporated territory that has adopted a local constitution for local affairs is typically referred to as a Commonwealth territory. Examples include the Commonwealth of the Philippines from 1935 to 1946, the Commonwealth of Puerto Rico, and the Commonwealth of the Northern Mariana Islands. Adoption of a local constitution authorized by Congress does not establish a separate or constitutionally guaranteed sovereignty. A possession is a territory that is within U.S. sovereignty, but which has no organized form of local self-government under federal law. It is merely property of the United States. A U.S. territory which becomes a separate nation is outside of U.S. sovereignty, possessing its own nationality and citizenship. This ends application of the U.S. Constitution and federal law as the supreme law in the territory, and U.S. sovereignty ends. A former territory that becomes independent and may or may not be ready to carry out all the functions of national sovereignty may enter into a treaty of free association with its former nation or a third nation. But this mutually agreed upon treaty of free association is not constitutionally guaranteed or permanent and is terminable at will by either party. Free association does not constitute a permanent union. Any rights granted to citizens of the free associated states, such as free travel and residency, are not constitutionally permanent or guaranteed. Just as there are distinct realms of political status within or outside of U.S. sovereignty, So too there are two realms of nationality and citizenship. Under U.S. law, there is a constitutionally defined form of nationality and citizenship that is permanent and irrevocable, and another defined by statute that is subject to the authority of Congress. This is called statutory citizenship. Under the 14th Amendment to the U.S. Constitution, a person born or naturalized in a state of the Union has irrevocable U.S. nationality and citizenship, as well as citizenship of the state of residency. It is lost only by voluntary and intentional renunciation. With constitutionally guaranteed citizenship, the terms nationality and citizenship have the same meaning. There is only one national citizenship of the United States. In addition to this constitutionally derived citizenship, Congress may extend U.S. citizenship to persons who do not otherwise acquire it. For example, persons born overseas of U.S. parents or persons born in a U.S. territory. This permissive form of citizenship may take different forms to serve policy goals of Congress. In case of citizenship established at the discretion of Congress, the terms nationality and citizenship may or may not have the same meaning. For example, Congress has the power to extend U.S. nationality to individuals or groups by treaty or federal law, but to withhold U.S. citizenship. This is what Congress did in the case of Puerto Rico from 1900 to 1917 and in the Philippines from 1900 to 1945. U.S. nationals born in those territories during those periods had U.S. nationality, but only a local citizenship status, even though it was defined by federal instead of local law. Even if local law also codified the federal citizenship law, the federal law was supreme. Persons born in a territory with U.S. citizenship will no longer acquire that status if the territory does not remain under U.S. sovereignty. There is no vested right to U.S. citizenship granted by laws enacted at the pleasure of Congress, just as there is no vested right to a political status created at the pleasure of Congress. Upon succession to separate sovereignty, persons born in the former territory will be aliens under U.S. law. As such, the citizens of the new nation will be eligible for immigration and naturalization on the same basis as other foreign citizens. Any special privileges granted by Congress to citizens of a former territory are not permanent in nature, nor will they be guaranteed. Congress has the authority to end U.S. nationality and citizenship within territories succeeding to separate sovereignty, or, in the alternative, it can require an election between U.S. citizenship and that of the new separate nation. To conclude, all matters determining the sovereignty of U.S. territories and the citizenship of their people are specifically provided for in the U.S. Constitution. This document is the empowering and limiting authority by which Congress governs territories and possessions. Its provisions are the benchmarks against which any claim to permanent sovereignty and American citizenship must be gauged. No matter how earnest the desire of individuals to avoid it or intense the political momentum to alter it, the movement of U.S. territorial people towards a permanent political status must recognize its tenets. They must chart their course in the full awareness of the wall which the Constitution of the United States places between its states and territories and all other categories of nationhood and citizenship that do now or in the future may exist in the world. I thank you for your attention.